There's a moment most gun owners dread. You're sitting behind the wheel, hands on the dash, license and registration already out. You told the officer the truth. You have a legally owned firearm in your vehicle, and then you watch his hand move toward your door handle. That moment just changed forever. A landmark Supreme Court decision has completely redrawn the legal boundary between your Fourth Amendment right to privacy and your Second Amendment right to bear arms. And I'm going to tell you exactly what it means, word by word, because most gun owners won't hear this anywhere else until it's too late. Before I do, hit that subscribe button right now. I know you've heard that before, but hear me out. I cover legal rulings that directly affect your rights as a gun owner the moment they drop. The next video I'm releasing covers the exact 5 words you should never say to a police officer when you're carrying. 5 words that gun owners say every single day without realizing it could land them in handcuffs even when they've done absolutely nothing wrong. Subscribe and turn on notifications so you don't miss it. Now, let's talk about what just happened. The Supreme Court issued a ruling that legal scholars are already calling one of the most significant Fourth Amendment decisions in a decade. And for gun owners specifically, it's even bigger than that. This isn't a narrow, technical opinion buried in legal footnotes. This is a clear, direct message from the highest court in the country about how your rights interact with each other and how they protect you during one of the most common police interactions in America, the traffic stop. Here's the core of it. The court ruled that a police officer cannot treat your lawful possession of a firearm as automatic justification to search your vehicle. Let me say that one more time because it is the whole ballgame. A legal gun in your car is not probable cause. It cannot be. And any search based solely on that fact, on your exercise of a constitutional right, is now clearly unconstitutional. Think about what that actually means in real life. You're a responsible gun owner. You followed every rule. You got your permit. You carry legally. You inform the officer when required by your state law. You've done everything right. And yet for years, in certain jurisdictions, that legal ownership was being treated as a flashing red light, a reason to dig through your glove box, a reason to pop your trunk, a reason to treat you like a suspect instead of a citizen exercising a right. The Supreme Court just called that what it is, a violation. Now here's something I want you to really sit with, because this is the part nobody is talking about yet. This ruling isn't just about traffic stops. It's about a fundamental constitutional principle that has implications everywhere. The principle is this: exercising one constitutional right cannot be used as grounds to strip away another. Your Second Amendment rights and your Fourth Amendment rights don't cancel each other out. They coexist. They reinforce each other. And the government, including law enforcement, has to respect both at the same time. That's a powerful legal statement, and it comes from a unanimous court. Every single justice agreed. In a time when this court agrees on almost nothing, 9 justices looked at this question and came to the same answer. That tells you something. That tells you the legal reasoning is airtight. That tells you this ruling will be the law of the land for a very long time. Let me break down what the ruling actually requires officers to have before they can search your vehicle. The legal standard is called probable cause. That means specific, articulable facts, not guesses, not gut feelings, not assumptions based on what you legally own, that point to evidence of a crime. The officer has to be able to point to something concrete, something they observed, something they can explain in court. What does that look like in practice? A smell coming from the vehicle, drug paraphernalia visible in plain sight, behavior that is clearly consistent with criminal activity, an illegal firearm visible to the naked eye. These are things that create probable cause. These are things that give an officer legal grounds to take a closer look. What doesn't create probable cause? You being nervous during a traffic stop, you being polite but not overly talkative, you having a carry permit, you informing the officer you have a legal weapon on board, you coming from a gun range, you having an NRA sticker on your bumper. None of that. Not one bit of it. Let me give you a real-world scenario so this clicks completely. You're heading home on a Friday night. You've been at the range for 2 hours running drills. Your pistol is secured in a hard case in your trunk, completely legal, completely compliant with your state's transportation laws. A cop pulls you over because your registration sticker expired last month. Totally normal, totally fixable. You hand over your license and expired registration. You inform the officer you have a firearm secured in the trunk, just like your state requires. Under the old way some departments were operating, that disclosure could be treated as a yellow light. An opening, a reason to start poking around for officer safety. Some officers would take that and run with it. Trunk open, bags checked, the whole routine, leaving you on the side of the road feeling like a criminal for owning a gun. Under this ruling, the officer writes you a ticket for the expired sticker, runs your license, hands you back your documents, and sends you on your way. Because your legal firearm, secured in the trunk, properly disclosed, is not a crime. It is not probable cause. It never was. That's the world this ruling is building. Now let's talk about officer safety because I want to be fair and accurate here. This ruling does not eliminate officer safety considerations. If an officer reasonably believes they are in danger, they can take steps to protect themselves. They can ask you to step out of the vehicle. In some circumstances, they can temporarily secure a visible weapon for the duration of the stop. That part of the law hasn't changed. What has changed is the limit. Safety measures exist for safety, not as a backdoor to conduct a search. The court drew that line clearly. There is a difference between what an officer can do to protect themselves and what constitutes a warrantless search of your vehicle. That difference matters enormously, and now it's codified in Supreme Court precedent. I want to pause here and tell you something directly. I spent years watching gun owners lose cases they should have won, because they didn't understand where their rights began and ended. They'd consent to searches they didn't have to allow. They'd say things that turned a routine stop into a nightmare. They had no idea that their legal gun was being used against them in court as evidence of suspicious behavior. That's not hypothetical. That happened. Constantly. And now we have a ruling that helps stop it. Only about 1 in 10 people watching this right now are subscribed to this channel. That means most of you are going to leave here today, get back in your car with your legally owned firearm, and have no idea that the legal ground beneath your feet just shifted in your favor. Don't let that be you. Subscribe right now. Stay in this community, because knowing this stuff isn't just interesting, it's protective. So, what do you actually do with this information? How does it change how you behave during your next traffic stop? First thing, know your state's notification law. That has not changed. If your state requires you to inform an officer that you are carrying, you must still do that, immediately and clearly. Do not think this ruling gives you a reason to stay silent about your firearm if the law says otherwise. It doesn't. This ruling protects you after disclosure. It doesn't change the rules about disclosure itself. Second thing, stay calm and cooperative. I cannot stress this enough. This ruling gives you legal protection. It does not give you permission to be confrontational or difficult. The roadside is not a courtroom. An argument about constitutional law on the shoulder of a highway rarely ends in your favor. Be respectful. Keep your hands visible. Speak clearly. Protect yourself legally and physically at the same time. Third thing, if an officer asks to search your vehicle and you have not given them any actual probable cause, you can decline. You are within your rights to say calmly and clearly, "Officer, I don't consent to searches." That's it. That's the sentence. You're not accusing anyone of anything. You're not being hostile. You are simply asserting a constitutional right that this Supreme Court just reaffirmed. If the officer searches anyway believing they have probable cause, that decision may be challenged later. But you've put your position on record. Fourth thing, document everything. If something goes wrong during a traffic stop, if you feel your rights were violated, write down every detail the moment you are safely away from the situation. What time was it? What did the officer say exactly? What did you say? What justification did they give for the search? Were there witnesses? Was there a dash cam recording? These details become your defense later. And with this new ruling, you have a much stronger legal foundation to stand on if the search was based purely on your legal possession of a firearm. Fifth thing, and this is the one most people don't think about, understand that this ruling is new. Officers on the ground right now may not have received updated training yet. Departments move slowly. That does not mean your rights are suspended in the meantime. It means you need to know them clearly enough to protect them, calmly, legally, and without escalation. If an officer tries to use your legal gun as justification for a search, you don't argue. You comply under protest if necessary. You say clearly that you do not consent. You document everything. And then you contact an attorney. That is how you fight back. Not on the roadside, but in the courtroom, where this ruling now gives you an extremely powerful argument. Let me also talk about concealed carry permit holders specifically, because this affects you in a direct and important way. Your permit is legal documentation that you are authorized to carry. Some officers in the past have treated a carry permit as if it were an admission of suspicion, as if the permit itself was a flag rather than a legal clearance. That logic has always been backwards. Your permit proves you went through the background check. You passed the training. You are following the law. It is evidence of your compliance, not your criminality. This ruling reinforces that. Your permit, your legal weapon, your constitutional right, none of those things can be used as the basis for treating you like a suspect. The officer still does their job. You still comply with lawful orders. But the legal presumption now is firmly on your side. Here's the bigger picture, and I want you to carry this with you. We live in a moment when Second Amendment rights are being fought over in courts, in legislatures, and in the court of public opinion every single day. Some forces want to expand your rights, others want to shrink them. And in the middle of all of that noise, 9 justices across every ideological background looked at a case about what happens when you exercise your right to bear arms and your right to be free from unreasonable searches at the same time, and they agreed unanimously, both rights matter, Both rights must be respected, and the government cannot use your exercise of one to justify violating the other. That is not a small thing. That is not a procedural technicality. That is a foundational statement about the relationship between the American citizen and the state, and it came from the highest legal authority in the country, without dissent. For everyone who has felt treated like a criminal for following the law, for everyone who has had their car torn apart over a firearm they owned legally, for everyone who has wondered if exercising their rights was worth the hassle, this ruling is an answer. It says, yes, it's worth it, and you should never have had to choose. What happens next? Expect challenges to past convictions where searches were based purely on lawful gun possession. Expect civil rights lawsuits from people who had their vehicles searched without actual probable cause. Expect changes in police department training protocols as departments work to get their officers aligned with this new standard. All of it will take time. None of it happens overnight. But the foundation is now set. The court has spoken, and the direction is clear. Laws change fast. Court decisions come down and reshape your rights before most people have even heard about the case. That's why staying informed is not optional. It's a responsibility. Subscribe to this channel, turn on notifications, because when the next ruling drops, you deserve to know about it immediately in plain language without having to wade through 100 pages of legal text to understand how it affects you. Let me wrap this up with what you need to remember. The Supreme Court ruled unanimously that your legal right to own a firearm cannot be used by police as automatic justification to search your vehicle. Officers need specific, articulable facts that rise to the level of probable cause. Your Second Amendment rights and your Fourth Amendment rights work together, and the law now says clearly that exercising one cannot be used to erase the other. Know your state notification laws. Be calm and cooperative during stops. You can decline a search without probable cause. Document everything if you believe your rights were violated. Understand that this ruling will take time to work its way through the system, but it is now the law of the land. This is a win. A clear, undeniable, unanimous win. Carry it with you every time you get behind the wheel. One final note. Everything I've shared today is educational information about this Supreme Court decision. It is not legal advice for your specific situation. Laws vary by state and jurisdiction. If you are facing charges or believe your rights were violated, contact a licensed attorney who specializes in constitutional and firearms law. They can look at the specific facts of your case and advise you accordingly. Stay safe, stay legal, stay informed.